Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In this episode, we'll delve into the tangled proceedings of the restitution hearing. As we've navigated through the proceedings in this case, we've uncovered a disconcerting pattern of deception and disregard for justice by those entrusted to uphold it. The revelations in this case showcase the erosion of our justice system with implications that extend far beyond an individual case. With each revelation, we have been confronted with the stark reality of how the very institutions designed to protect our rights may be complicit in their violation. In this exploration of the restitution hearing, a crucial chapter exposes the systemic challenges we all face in preserving the integrity of our Constitution. To set the stage, I had already been coerced into pleading guilty while maintaining my innocence, which I discussed in the episodes 6 and 8 of this series, with the waiver of rights and the sentencing. This was not an Alford plea. It's a paradoxical situation that epitomizes the convoluted nature of my case. The court, in its sentencing, claimed adherence to established guidelines, yet the disparate sentence handed down contradicted this assertion, setting the tone for a legal battle fraught with harmful, systematic errors. Following my guilty plea while asserting my innocence, I reiterated my innocence during the parole hearing in prison, where parole was then denied. After serving the stipulated 2.5 years for count 2, larceny, I sought an investigation into the legality of the court proceedings by the Committee for Public Counsel Services in March of 2015, as we explored in our previous episode, CPCS Investigation. This inquiry spanned to September 27, 2017, the day of the restitution hearing. Astonishingly, despite concrete evidence of court irregularities that I have shared with you throughout this series, all of the investigating attorneys declared my claims of fraud to be meritless. On October 3rd of 2017, the Director of Appeals at CPCS notified me that I would have to proceed pro se. However, the court docket indicated that Attorney Stacey Gross-Mama was appointed on January 2nd of 2017 for appellate action, ostensibly bypassing the need for further screening by CPCS. Then, probation initiated a surrender hearing in May of 2017, a shrewd tactic to strip me of legal representation for any appeal. This led to Attorney Gross-Mama's removal and the appointment of Attorney Jeffrey Higgins for the surrender hearing. However, a problem arose for the court. How do you proceed with a surrender hearing while the case was actually still pending? This sequence is what prompted the court to schedule the restitution hearing multiple times, from June to September, culminating in a hearing on September 27, 2017, the same day Attorney Gross-Mama dismissed my claims, depriving me counsel for any post-conviction motions. Amidst the unfolding legal drama, a shift in my personal landscape marked the appointment of a third probation officer, Kimberly Bowden. This change was triggered by the passing of my ex-wife's new husband, an employee of the Billerica County Jail and an alleged victim of the dismissed case. This led our children and my mother-in-law to relocate with her, and due to financial constraints, a subsequent invitation to move in with them, rooted in familial ties, meant a fresh start for me in a new jurisdiction under the watchful eye of Probation Officer Kimberly Bowden. Then, a disturbing twist surfaced during the discovery phase of the restitution hearing. Attorney Jeffrey Higgins, tasked with this segment of my legal journey, summoned me to his office to collect some documents. To my dismay, the file harbored police reports from the dismissed case involving my ex-wife and her now-deceased husband, with a posthumous letter he wrote to the district attorney's office fraught with defamation and accusations against me. These materials bore no relevance to the ongoing case, mirroring the insignificance during the lobby conference and sentencing. Yet they were resuscitated back into the narrative deliberately and shamefully. It became apparent that this maneuver, orchestrated by the specially appointed counsel Debra DeWitt, aimed not only to muddy the legal waters, but to sow discord within my family. I quickly recognized the calculated intent to jeopardize the safety and harmony of my home, a move both unethical and immoral. The line between legal strategy and personal vendetta blurred, underscoring the lengths of depravity to which some were willing to go in this turbulent pursuit of justice. This came after the CPCS investigation of DeWitt and DeWitt's being presented with the Honorable Paul A. Chernoff Servant of Justice Award. In the unfolding of recent events, on September 30th, 2023, I initiated contact with Attorney Higgins, conveying my intention to feature him in this episode of Constitutional Fraud. And I formally requested my case file for this purpose. In response, he explained that he typically retained files for 7 years and initially claimed that he couldn't locate it due to its being in storage, which was understandable. He eventually notified me that he found it, prompting a visit to his office to pick it up. Notably absent were the minutes from the restitution hearing. Subsequently, Attorney Higgins notified me that the New England Innocence Project had also sought the file, requesting I forward a copy to them on his behalf. While I reluctantly agreed at first, upon closer inspection and consideration of potential complications, I decided against forwarding the file, and I expressed my concerns to Higgins. I opted to exercise caution, choosing not to be responsible for any potential discrepancies or issues associated with the file's contents, particularly given its inclusion of the police reports from the dismissed case. And now, a word from our sponsor. This episode of Constitutional Fraud is brought to you by Massachusetts Rules of Evidence, Section 1114, Restitution, Part C, Judicial Determination, which states, the amount of restitution ordered by the court must be based on evidence presented to the court or on a stipulation by the parties. The judge must determine 1, the amount of actual economic loss proved, and 2, the appropriate length of the probation period, and finally 3, the defendant's maximum monthly ability to pay. Now back to our episode. The monetary value of the stolen items was reported to be $67,000, of which $28,000 was paid by the victim's homeowner insurance. Amidst the proceedings of the restitution hearing, I sought to exercise my fundamental right to cross-examine each stolen item, a right affirmed by my personal research into legal matters associated with our sponsor for this episode. However, Judge Ullmann, invoking a questionable discretion that he did not possess, summarily denied me this right. There would be no cross-examination allowed. Undeterred, I stood on the record reaffirming my unwavering claim of innocence and articulating my intention to file a Route 30 motion for a new trial. I also instructed Attorney Higgins to convey to the court that the sentence for larceny had been fully served, devoid of any restitution obligations which are associated with probation. These declarations set the stage for Judge Ullmann's ensuing decision and order, a pivotal moment encapsulated in his written pronouncement. Allow me to share it with you. It's 2 pages. Commonwealth versus William Toppi, Memorandum and Decision and Order on Restitution. On December 17, 2014, the defendant, William Toppi, was sentenced to a prison term followed by 2 years of probation on charges arising out of his theft of property belonging to Priscilla Niccolo. The court ordered restitution to be paid and the amount to be determined later. The amount of restitution was never determined, and therefore no order to pay a particular amount of restitution was ever entered. Toppi's term of probation terminates on December 7, 2017. The Commonwealth now seeks restitution for that part of Niccolo's losses that was not covered by her insurance. Toppi is not in violation of any condition of probation. Under Commonwealth v. Henry, 475 Mass 117, 2016, and the particular facts of this case, the court cannot extend his term of probation for the purpose of paying restitution that was never determined. The court is therefore limited to ordering an amount of restitution that can be expeditiously be determined and that Toppi can reasonably afford to pay by December 7, 2017. Based on the financial information submitted by Toppi in the possession of the probation service, Toppi cannot be reasonably afford to pay more than $1,000 between now and December 7, 2017. This amount is the amount of the deductible for Niccolo's insurance policy, which is not in dispute. It is therefore ordered that on or before December 7, 2017, defendant William Toppi shall pay restitution in the amount of $1,000 to Priscilla Niccolo. Judge Ullmann, Justice of the Superior Court, dated October 18, 2017. The order, while clever, lacked documentation and relied solely on the victim's word, exemplifying the arbitrary nature of the proceedings, never confirming the amount of the deductible in violation of our sponsor for this episode. Not to mention that my right to cross-examine was also denied in violation of the same rules of evidence 1114. Attorney Higgins filed an appeal at my request on October 30th, 2017. However, the stark reality was that the Massachusetts Committee for Public Counsel Services had already communicated to me that I had no entitlement to legal representation for an appeal, echoing a similar abandonment during this restitution appeal. This disheartening scenario left me navigating the complexities of the legal process without the support of appointed counsel, highlighting a profound sense of isolation and injustice in my ongoing struggle for justice. My relentless pursuit to avoid paying the contested restitution order or any other fees related to the fraudulent conviction threw me back into the heart of the legal battle on December 14, 2017. In the Lowell Superior Court, I faced the scrutiny of Judge Kathy Tutman, who pondered the option of holding me in contempt. The subsequent day, December 15th, saw me once more before Judge Ullmann, just 2 days before my 2-year probation was set to conclude. In a twist of fate, he opted to extend my probation for another year, effectively delaying any restitution payments until after the appeal, a legal ordeal I faced without the support of appointed counsel. This extension added another layer of complexity to an already convoluted and unjust legal saga. This saga of threats and legal battles without counsel persisted as I faced another summons for probation violations on November 20th of 2018. Curiously listed as proceeding pro se in the court docket, despite my never expressing a desire to do so, I found myself navigating the legal labyrinth without appointed counsel. I staunchly maintained my innocence and true to form refused to yield to the financial demands associated with the conviction. Judge Kenneth Salinger waived the looming DNA fee that had cast a shadow of threats over 3 years of probation. A month later, on December 17th, 2018, 5 years to the day after the fraudulent conviction, I was back in front of Judge Salinger. The hearing unfolded without the presence of Probation Officer Bowden. Astonishingly, a representative from the probation department admitted they were uncertain about how to proceed on the matter. The absence of anyone from the district attorney's office added to the surreal atmosphere. Judge Salinger terminated my extended probation, remitting and waiving the restitution that had been the focal point of contention. I objected for the record, but was seemingly disregarded as court officers ushered me away. My son was present with me at this hearing. Adding an unexpected epilogue, on February 20th, 2019, Judge Lawrence Pierce quietly dismissed all outstanding monetary obligations without my knowledge or attendance at any hearing. The only fees ever paid with regard to this fraudulent conviction were from the seizure of my canteen funds while I was incarcerated. And the disconcerting reality underlying the numerous court hearings and persistent threats to upend my family life during the initial 2 years of probation, followed by an additional extended year, is the unsettling awareness that every legal professional involved, be it lawyers, prosecutors, or judges, had full access to the unequivocal evidence pointing to harmful, systematic errors and fraud orchestrated by Judge David Ricciardone and the attorney he specially appointed to represent me, Debra DeWitt. Each subsequent professional legal expert, upon reviewing the case within the context of their professional duties, knowingly became complicit with the obstruction of the crime at the expense of our United States Constitution. This unveils a shocking facet of the intricate workings of the Massachusetts political criminal justice system, where fraud appears to be an unsettlingly routine part of the court's business. In our upcoming episode, we delve into a critical juncture in the constitutional fraud series. Join me as we navigate through my pro se Rule 30 motion seeking a new trial, a pivotal moment marked by its filing on July 16th of 2020 amid the COVID pandemic. The narrative takes a surprising turn when Judge David Ricciardone's unexpected invitation to a non-evidentiary Zoom hearing, considering the undeniable fact that this same judge, who I now knew had lied to me, extended an invitation, the trustworthiness of such an offer became a central theme. I declined his invitation, weary of the complexities surrounding his past deception. This episode unravels the intricate dynamics surrounding these events, providing a closer look at a judicial process marred by questionable actions. Stay tuned for Motion for a New Trial as we unravel these complexities and more. Until then, I'm your host, William Toppi, emphasizing that our pursuit of justice begins with you,